Thank you, Mr.
Yes.
Yes.
I'm,
Who are you appearing for?
I am for the writ petitioner who had filed the writ petition in January 2018 against the effacement of all articles in respect of me in relation to Jammu and Kashmir. Part 3, effacement of Part 3, a core value from the Part 3. I challenged that before this court and that has been tagged. Enough has been argued, but I am arguing for class, that's Radhika Gill versus Union of India.
Which is that?
Radhika Gill versus Union of India, and my synopsis is at page, the compilation is 426. I'll take only 2 bits, mal. This Radhika Gill and the other person belongs to that class who are descendants to those persons who have been lifted from Gurdaspur to Jammu and Kashmir in 1957 to handle the sanitation problem which had arisen on account of the long strike in Jammu and Kashmir. So they were settled in the outskirts of Jammu and Kashmir, and my lord, that now has converted now with the passage of time. Those are the slums, no property rights, etc., no education rights, etc. Now, my lord, your lordship may kindly see my prayer. The whole effacement of Part 3 in relation to Jammu and Kashmir, I have challenged in my writ petition. Your lordship may kindly see the Solicitor General referred to Article 14 effacement also. Your lordship may kindly see 35A Clause A. What exactly it does? It does one thing, my lord, delegating the power to the state legislature to define the permanent resident and not challengeable. That's what, my lord, the delegation has been done to the state government, state legislature, my lord, in this class, my lordship, defining the class of permanent resident and delegating it to state legislature and not challengeable. So, my lord, your lordship have not allowed such a delegation to the state government so far as the Part 3 aspect is concerned. So that's what the solicitor said, that core value of Article 14 has also been taken away. And with the aid and assistance of this delegation, Section 6 was incorporated, and this is nothing but a homage to defined ancestry and none else. Whosoever is there on a particular cutoff date, I was there in 57 only, my lord. So my predecessors were in 57. And we were there, and now we are denied. I am born there, and at least no fundamental rights are available to me. That's why I challenge that right to education. Section 6 has also been challenged in that petition. Now, your lordship, I am now, so far as my synopsis is concerned, paragraph 17 and subparagraphs have dealt with 3 aspects. One is the powers are precedent are constant in nature. The lordship may kindly see paragraph 7, subparagraph B.
That's argued. That's
now, one thing. Relationship between 368 and Article 37.
That's been also argued. Yes.
No, yes, I have taken this. I have taken this herein. That.
Thank you.
Thank you. Anything else? Yes. Yes. What about you?
I am appearing in Malad I number 153121.
I number
153121.
15153.
153121 of 2019. That's Roots in Kashmir. Roots in Kashmir is an organization which is espousing the cause of Kashmiri migrants, now called displaced persons. Since 1989, there are 5 lakh people.
What is the
That's one. That's one petition. Number 2 is Dr. Charu Wali Khana. That's a substantive writ petition in 2017. 369. That is. Just give me number. What's the number? 396 of 2017. Submission is I am given detailed written submission that are conjoined written submission.
Page,
volume 3, page 444 to 456. And for convenience, I have filed a small note, 3-page note, which was taken on record. I read it.
All right, we'll have a look at it, but you can just sort of in 1 minute just highlight what is the central point.
I'll say. I'll say, my lord, the instrument of accession dated 26/10/1947, my lord, is final and issue of proclamation, and the Article 1 and is completely applicable, my lord. So it has, it's being an integral part of the, my lord, India, domain of India, my lord. Then, my lord, I say,
There
my
is
lord,
something which has not been argued.
my lord, it's not, my lord, it's not, my lord. I say, my lord, with respect to the Article 370, which has been raised, my lord, herein, that the devolution of power of Constituent Assembly is transferred to the Legislative Assembly, as there is no Constituent Assembly as on 57. Therefore, it's not the.
That has already been argued so many times.
No, it's not, my lord. It's not, my lord. Concurrence given to the government of the state, but also repository. My lord, ratification has been done to the parliament. So absolute majority, parliament has rectified the decision. One is that. Two is, my lord, and my lord, it's not a basic structure. As my lord held in, my lord, I am going to.
Got the point.
I have, my lord, relied in my, my lord, I relied on my, 1973 for SEC volume 15, my lord, in Keshananda Bharati of Justice, my lord, Justice Khanna. He has given that, my lord. And, my lord, then Bomai also, it's not a federal, it's a quasi-federal, my lord, state. Then Puranlal Lakhanpal and, my lord,
That is now being covered.
modification.
Covered,
My lord, I had added one judgment, my lord, because I could hold that. That is, my lord, S. Sant Singh and others versus State of Jammu and Kashmir, reported in 1959, Jammu and Kashmir, page 35. That's a full-page judgment, my lord, which deals with modification clause of, my lord, Article 30, my lord, Article J&K Tenancy Act, my lord. That is AR 1959, Jammu and Kashmir, page 35. Dealing with the challenge to provisions of Jammu and Kashmir Tenancy Act inserted in 9th schedule was upheld and did not violate any of the fundamental rights conferred under Article Part 3. See, this is, my lord. Then Coelho, as my lord said, that it said it's not a fundamental, it's not a violation of fundamental rights under Article Para 102. My lord, Coelho is that page, my lord.
Coelho has been argued so many times. Everybody has referred to Coelho.
Then, my lord, we have very less time, my lord. That's why, my lord, I'm just going through all these things.
To Mr. Dwivedi.
Indra Sani, my lord. Indra Sani, my lord. My lord, 35A, my lord, I have challenged the substantive writ petition, my lord, in 2017, which a notice was issued, and this was referred to the Constitution bench in that time only, my lord. Then it was tagged along with this, my lord. So I have 4 judgments to cite on, my lord. Indra Sani, that's equality. 19. My lord, what has happened in this, my lord?
You put it in your note.
My lord, I said, my lord, 27 and 32 notification.
We have 3 minutes now. Let's hear some other people.
I'll take 3
Otherwise
minutes. I'll take 3 minutes.
Let's.
I'll take 2 minutes. I'll take 2 minutes.
No,
27.
You have to close at.
My lord, 27 and
Yes,
30.
Mr. Banerjee, what do you have
I'll say,
to
my lord.
say?
I'll say why.
My lords, I am.
We'll read your written submissions.
One. Then.
I am appearing in IA 146764, my lords.
My lord,
Points that need to be
Just-
responded. Petition from 20. If my lords allow.
No, that absolutely not. You have to conclude. We have to conclude by lunch. I mean, we had made that clear yesterday.
my lord, my 1 minute they'll take, my lord. My lord, I'll say, my lord. I'll say, my lord.
Mr. Jad, we have.
My lord, I had.
We had said that, look, we are going to conclude at 1 o'clock. We had requested everybody to so structure their arguments that the others who follow have time. We are not going to cross 1 minute after 1 o'clock for
Yes,
this
my
side.
lord. I'll read the affidavit, my lord.
Absolutely.
I'll read the affidavit, my lord, which I mentioned in the morning, my lord. My lord.
You can argue for the next 3 minutes, but you know what the consequences. We are rising at the stroke of
My
lunch.
lord, I read. My lord,
Yes.
let
We are
me read-
starting with the rejoinder.
let me read the affidavit.
See, this is not fair. You said
This is
I will give my
filibustering.
half an hour to Mr. Dwivedi.
My lord, half an hour to me, my lord. I could curtail my half.
Mr. Jad, you
Half an hour.
specifically said
Gave your half an hour to.
My lord, can I read
that
the
I'm
affidavit?
giving my half an hour to Mr. Dwivedi.
My lord,
But
can I read my affidavit, my lord?
We'll read it. What is
Read it, my lord.
we are rising at 1 o'clock.
In my affidavit, my lord, I'm making only one submission, my lord.
The
Let
element
Mr.
of
Lone
civic
make a
consciousness
statement or
must also
affidavit
apply
that
to legal
effect
arguments
that
and
he's a citizen of India and he doesn't, my lord, support terrorist states, my lord. Let him put an affidavit, my lord. Mr. Sibal,
That has been
counsel
put
is
by the
here, my lord.
solicitor also in the morning.
All right, 1 second.
Please.
Just 1 second now. Just 1 second.
Please.
Mr. Agrawal, what point do you want to make? Just formulate it. Come.
Affidavit, my lord.
Federal diversity, the element of Dr. Chavan is.
My lord, only one thing, my lord. Mr.
Your
President,
time is up. Your time is over.
President of the bar is
Your
here, my lord.
time
Jammu
is-
Kashmir President. My
Your
lord.
time is over.
My lord, I was appearing for Jammu and Kashmir High Court Bar Association. My lord, President of the bar is here, my lord. He wants to say something. My lord. That's all, my lord. I am curtailing my argument.
We are in charge of whom we will hear. You are not in charge of who will follow you.
My lord, I don't.
Mr. Kanu Agrawal.
Okay, that's, my lord, I leave it to my lord.
Short pages that I have submitted. Federal diversity, my lords, Dr. Dhawan sought to rely on the judgment of R.C. Podial. If my lord sees, to my understanding, federal diversity in the Indian Constitution exists on a two-dimensional plane. At the center would, as far as I understand, would be the classical states, would be the classical understanding of a state the state which has fully governed by Schedule 7 and other provisions of the Constitution. To the right of it would be states which have limited special features, would be states like the limited features like Gujarat or Maharashtra, all taken through by Dr. Dhawan. Thereafter would be states which say fall under the 5th schedule and the 6th schedule, and some other states which have further special features. To the right end of it, perhaps, was the erstwhile Article 370. What the petitioners forget, my lords, is that there is a scale to the left of it as well. The scale to the left of it is the union territories with legislature, is the union territory of the GNCT of Delhi, and further, perhaps, pure and simple union territories. Therefore, federal diversity, my lords, it's undoubted that diversity is a constitutional fact, but not all constitutional facts can be elevated to the level of basic structure. When we adopt the identity test in terms of identification of basic structure, not all constitutional facts become basic structures. R.C. Podial was relied upon to further the argument that this diversity, a manifestation of which was Article 370, erstwhile Article 370, is a part of basic structure. Incidentally, my lords, para 128 was read in R.C. Podial. If my lord sees the last 3 lines of para 128, I think that those last 3 lines itself completely demolish the case of the petitioners on federal diversity, because those last 3 lines itself indicate that these provisions which were in consideration in R.C. Podial were for a limited transitional period. The word transitional has been used. Therefore, my lords, as far as the fact that federal diversity may be integral, it would not necessarily lead to it being a basic structure. The method and the methodology adopted by the union, whether under 368 or 373, has been fully taken care of. I don't wish to address it further. The second point is on, my lords, Constituent Assembly and the nature and the nomenclature of Constituent Assembly. Mr. Gopal Subramaniam specifically highlighted that there are no hierarchies. That was his assumption, that there are no. At a normative level, that's an absolutely correct statement. There cannot be any hierarchies in Constituent Assembly. However, there are not many things that move on a normative level in Jammu and Kashmir. There are 3 facts in this regard that my lords need to see. There are 2 kinds of constituent power. One is original constituent power, and the other could be derivative constituent power. It was on this jurisprudential basis that Keshwanand Bharti was delivered, and thereafter other judgments, which state that the original constituent power is always with the original Constituent Assembly, the plenary power. But derivative constituent power is something that is always with further legislatures, the parliament in this case. Therefore, the question that we need to interrogate is whether the Constituent Assembly of the Jammu and Kashmir Constituent Assembly had any original constituent power. The 3 facts, which according to me clearly point towards the fact that they had no original constituent power, were A, it was established under the proclamation of a Maharaja that had already signed an instrument of accession. Number 2,
Just one second.
it's there in the 3 page.
Yes.
Number 2, the Maharaja had already issued a proclamation dated 25/11/1949, recognizing the supremacy of the Indian Constitution. And number 3, unequivocally, Article 1 was in force. So on the date in 1951, when the proclamation to establish the Constituent Assembly of Jammu and Kashmir was issued, the Maharaja, who was not a sovereign, could not have passed a better title than what he had. If he was not a sovereign, the Constituent Assembly of Jammu and Kashmir could never have been a sovereign Constituent Assembly, could never have established a sovereign constitution. The suggestion from the other side is that under 370 sub-article 3, they could have severed their ties with India at the time of dissolution of the Constituent Assembly. My lords, I submit that is an absolute impossibility as far as the Indian Constitution is concerned, because Article 1 would have applied to them irrespective of
Agrawal,
the nature of
page,
Article
which
370.
is the page of your written submission in the
That's page 2.
no in the volume 3.
My lords, that is not there in volume 3.
Add kar do usko.
My lords, if my lords allow, please.
All right, thank you.
Please, my lords. Just one more aspect, my lords.
Yes.
If the J&K Constituent Assembly had no original constituent powers, it automatically exercised only derivative constituent powers. If it is exercising derivative constituent powers, it is akin to a legislative assembly. My lords, one of the letters that was highlighted by Mr. Shankar Narayan was a letter by Rajendra Prasad to Mr. Nehru. My lords may remember 1952, 6th
Yes.
of September, I think, 1952 by Rajendra Prasad. That letter finds mention in Mr. Noorani's book at volume 20, page PDF 222, I believe. Mr. Noorani has done a lot of research. He should have also pulled out the letter which was written by the then Prime Minister, Mr. Nehru, in reply to the letter of Rajendra Prasad. Mr. Nehru wrote a letter dated 7/11/1952 to Mr. Rajendra Prasad on a host of issues after Mr. Rajendra Prasad had also written a letter to the then Home Minister K.M. Munshi. And he highlighted the fact that how this issue has been discussed with the law officers of the union at the highest level with Mr. Gopalaswamy Iyengar and with other people. I have annexed it to my note, my lords. And therefore requested the president, requested being the word, requested the president to consider passing the CO. That was on 7th of November 1952. Within 8 days, my lords, the learned president passed the CO 44, which was 15/11/1952 under 373, thereby changing Maharaja to Sadar area. Therefore, my lords, I think the SG had also pointed it out that actions speak louder than words. That is all that I
Yes, Mr. Vikram.
My lords, I'll just make a small submission. My lords, everything is, my lords, my submission is this. My lords have seen the original constitution. The original constitution,
Biju, move towards the center.
my lords, the original constitution, there were transitional and temporary provisions. It wasn't, the special provision was subsequently added as an amendment at a later point of time. So the original constitution in this chapter was as to temporary and transitional provisions. So the very fact that this is taken to be a transitional and temporary provision means that this is the entire objective of the original part. Subsequently, a large part of it, my lords will recall, has from 75 to 91 have now been amended out. So the original intention of including 370 in that chapter, and it was in the genus of that, was this was a transitional provision. And my lords will see 391 and 392, there were presidential powers which were given
All right.
to make amendments.
Thank you, Mr.
My
Ban.
my only submission is this was permissible to
This has been
follow.
already argued, Mr. Banerjee.
Well, it's-
Thank you, Mr. Banerjee. Now, Ms. Pathak, come along, come forward. 1 second, we'll call out. We are calling out people. Don't jump the gun. Yes.
1 minute, my lords.
1 second, Biju.
Yes, I'm sorry.
Yes, Ms. Dave, what do you want to?
I'm appearing in an IA 171722 of 2019.
So what's the point, tell us?
Well, it's the point that I'm making is, well, it's the permanent residentship. Well, it's no one has talked about the rights of the women that were taken away. So the permanent residentship would not come to the women who have married outside the state of Jammu and Kashmir. So, my lords,
That
if
was set aside. That was ultimately constitutionally.
yes,
set
my lords, state of J&K versus my lords, Dr. Sushila Sahani 2002 judgment. In fact, the full bench of the Jammu Kashmir High Court held that they will have permanent residentship even if they marry outside. But the state then, my lords, the learned AG there made a statement that they will not get, in fact, my lords, the right to employment, right to scholarship, as well as the right to hold immovable property was taken away if you marry to a person who is outside the state of Jammu and
Thank you.
Kashmir.
Thank you.
Well,
Mr.
it's my written
Biju?
submissions.
Yes, we'll take.
I have,
What is your page of the written submissions?
I'll give it to the learned court master, my lords. We had submitted to the nodal council.
All right.
2 pages only, my lord.
Volume 3, right?
Yes, my lords. There's
Yes,
one,
Biju.
my lords. We have got these rights now after 2019. Can a writ petition filed under 32 take away fundamental rights given to the other citizens of the country, my lords? Is my respectful submission. I'm obliged, my lords.
Yes, my lord.
Yes, Biju.
I am appearing for my client who is a retired major. He dedicated his substantial time in the area in question, which is J&K. And my lords, my IAS 171000 of 2019 petition civil number 1082 of 2019, my lords. Kindly note this because my,
Biju, just make a point now.
yes, my lords. 171000 of 2019 is WPC number.
We'll see that. You just make what.
Just what's the substance, what's
Yes,
the
sir.
point and substance?
My point is this, my lords. Before that, my lord, page 5152 to 525 of volume 3, my written submissions, where I substantiate what are the ground realities, where I substantiate what was happening, as my lords already asked. My lords, what is after going again and again, 370, sub-article 3, proviso, there is a special provision. And if it is non-functioning, then what is the way out?
This
That-
point
my
has
lords,
been
let
argued.
me- What is it?
Come
This is
on
what
now,
my
tell
point.
us something.
What is the next remedy, my lords? My respectful submission, my lords, is extremely clear in the Constitution of India, Article 368(1). Then 2 is saying that, or 368(2) says that if so and so articles or chapters, if you are going to touch, or if you are going to touch basic structural principle, then you have to have the ratification of the 50% of state governments. In that subclause 2, there is nothing to do with 370. So 368(1) is starting itself is, my lord, extremely important, that language, that notwithstanding anything contained in.
Well, thank you.
Notwithstanding
Thank you,
anything.
Biju, we got the point. We got the point. Thank you. Sir, there at the back.
One more.
Biju, there's somebody at the back from Srinagar, Jammu, who is.
Going, my lord. This is one area, my lord. Then my respectful submission, my lords, what I did again and again, my lords, I was repeatedly reading my lord judgments from 1950 onwards, at least 5 judgments, which are constitutional judgments, saying that there is every power for Indian Parliament and the President of India.
Thank you.
That time, my lord, separately indicated in paragraph.
We'll see on that. Yes, what is your point?
I'm grateful just for the time. Lords, I'm appearing in 108-743 of 2018, Lords. There's an IA filed, Lords, by the Bar Association, High Court of J&K and Jammu. Now, Lords, I adopt, Lord, the submissions of the SG and everybody, Lord, who is supporting this, Lord, CEO. One submission, Lord, if the Honorable Court would permit me, is that whether, Lord, at this 76th year of our association with a country, a question mark, Lord, on our nationality also would not hit, Lord, in the extended interpretation of Article 21. If I would seek the Honorable Court's indulgence, Lord, that whether right to live with dignity, Lord, starting from Maneka Gandhi's 78, would also include, Lord, a right to have a nationality after having lived with the country and identified oneself with. So, Lord, we take pride in being Indians outside of India. But when it comes, Lord, within India, can there be somebody, Lord, allowed to raise a question mark on our nationality? Because, Lord, when I was, Lord, following this, Lord, debate on the VC from J&K, questions like referendum also, Lord, were addressed. Now, in this, Lord, 75th Golden Jubilee, which we say, if, Lord, at this point in time also, a question mark on our identity with a particular nation where we have contributed and will live with pride within India, if this is still, Lord, is hanging in balance, though, Lord, we owe our, Lord, gratitude to the Constitution that this debate is still permissible. But then, whether the Constitution, Lord, can be so flexible as to include a debate also as to a person who has contributed a lifetime. No, this is the 3rd generation, Lord, into it. Now, from 47 onwards, we are now, Lord, in 2023. And in 2023, Lord, if I have to prove to somebody that I am an Indian, whether, Lord, my life is actually a life of dignity, is, Lord, my humble submission. I'll seek honorable bench, Lord, indulgence.
Thank you very much.
I'm grateful.
Thank you.
Lords, 35A is linked to Section 6 of the Constitution of Jammu and Kashmir and is linked to 370. If 272 and 273 is not upheld, what the consequence is that there is a tap on the application of the Constitution of India, including Part 3, which can be turned on, turned off at the discretion of the state government, which by itself is inherently discriminatory, abusive. Yes, which has been therefore, apart from IR Coelho, I think most important is Puttaswamy, where your lordships have upheld the socio-economic interpretation, because for a long time fundamental rights were essentially social in nature, but an economic angle has been brought about. Our problem is we are being deprived of that. One very brief point, my lords, the consistent position of Republic of India, and I deliberately say Republic of India, before the United Nations Security Council is that there was no sovereignty of any kind, slightest nature, residing with the state of Jammu and Kashmir, neither under international law, nor under comparative constitutional law. For comparative constitutional law, there's an opinion of Dr. Ambedkar, which is in my submission, where he said why there is not even an iota iota of sovereignty with any princely state, including state of Jammu and Kashmir. In international law literature, it is very clear, settled position of customary international law, which was also taken by the Republic of India in the Security Council in MC Chagla's speech and also Krishna Menon's speech, very clearly spelled out that under international law, there's no possibility of any such constituent, which is an integral part of India, to have any sovereign right. So that is clear. So therefore, no question of Constituent Assembly or Maharaja having any sort of sovereign power. In fact, it was made expressly clear in the Security Council itself by both of them that aspect rests entirely with the Union. So what is being now called as residual sovereignty can't conceptually exist. It contradicts the very idea of sovereignty propounded by Bentham, or even by Max Huber. Therefore, sovereignty, there is only one sovereign. All that they can have is legislative competence, that is also to minimal extent. Apart from that, there was a major argument which was made that instrument of accession had to be approved by JK Constituent Assembly. It wasn't necessary. The only requirement was Section 6 of the Government of India Act. This was the consistent position again put forward by MC Chagla before the United Nations Security Council. Also under section, one very last point, India was the successor state which included princely states. That comes from section 311 of the Government of India Act. Therefore, by virtue of that, India already a singular entity where all sovereign authority rests with the Union and the constituents don't have any other power. To use the phrase of Krishna Menon, they are sub-sovereign entities.
Yes.
Advocate General,
And nothing for
UT.
Yeah.
United Nations. This is past history. There is nothing pending in United Nations or anything. It is our internal.
Yes, my lords. Yeah.
There are history.
Yes.
Only thing I was saying, that's the position, that there's no such internal.
Being the AG, first of all, I subscribe to the submissions made by attorney and solicitor general and my colleagues on this side. One aspect perhaps need to be brought, but the basic fundamental rights include the health also. And health generates from the health medical education. All judgments, whenever it would come, I am passing a judgment to Lordship just now. But kindly see the plight in J&K. Whenever it comes to the taking a health care, the point would be that we, because of 370, will not allow for those benefits which are emanate from Article 21 to flow to J&K. Now I am passing to judgment of this Honorable Court. But whenever this issue comes, this is 1984, where they say, yes, for the rest of the country, that she's sending 70% of seats and 30% local, it's funded. But when it comes to J&K, even this Honorable Court says, we'll wait till the time comes. How long will this medical facilities, which are, just have a look to these judgments. Right? In this last paragraph, the court says, so far as J&K and Andhras are concerned, we are told that there are some constitutional provisions and therefore we deal. The result was that for so many years, the erstwhile state of Jammu and Kashmir and now UT remained deprived of the basic fundamental rights, including the medical education. So let's just have a look to this.
We'll have a look at. Thank you, Mr. Advocate General. Thank you.
There's a short
All right,
Holding my-
everyone 1 minute each. Yes.
Yes, my lord.
Just before I conclude, all speeches, because I know that time, all exercise, understanding and the literature, one word is very important. All leaders, including Mr. Sheikh Abdullah, in unequivocal terms said, accession, not the aggression. In the parliament on 8 January 48, everywhere. No blood, even at this stage of 75 years, yet we have to define our relationship with it. But as Article 371, Part D, Part 3, they were discussed so. In all cases, we are the integral part of this great nation, Union of India. All arguments to the contrary are too late in the day when the Constitution of India had all its place, and now it is only academic, otherwise we are a part of that. I'm grateful.
Thank you, Mr.
My lord,
Advocate.
the short submission. This amendment A cannot be seen as a silo in light of the larger transformative nature of a constitution. 3 bullet points that come in it. The violation of rights of those who are persecuted is so extensive, my lords, that it has been recognized as a grave human right violation in 2019. A violation, my lords, which is considered an international crime in international law, therefore attracts customary international law and is jus cogens norm.
So therefore, my lords, when such an acknowledgement does come in, really a case for restorative and transitional justice does arise. So clearly, my lords, those who have been persecuted and they want to go home, it will have to happen that security is ascertained and restorative and transitional justice does arise. So fact-finding missions, truth commissions, transitional commissions, therefore become the norm. Unless and until, my lords, an amendment of this nature does not come in, that takes away the conditions of oppressions that were there and that ensured that they were not only persecuted but had an exodus in 89 and 90 is not taken away. This higher feature cannot really be attained, my lords. So therefore, my lords, I submit that this has to be seen holistically. And attributing of responsibility. My lords.
You can put it in your note. It's in your note.
Millards.
Now, I'll limit my intervention on just two aspects, my lords. One is the proviso under Article 3, my lords. The contention of the other side was that the requirement of taking the views of the state legislature is a condition precedent. My lords, as the learned Solicitor General has shown already that wherever Article 356 was invoked, this proviso to Article 3 was suspended. Secondly, my lords, the views of the state legislature under the proviso are not binding on the parliament. Your lordships have so held in Babulal Parate's case. Thirdly, my lords, Article 3 is a plenary power. So any interpretation, any construction cannot be given to the requirements of obtaining the views of the state legislature, which denudes from this plenary power. My lords, the second argument is the Rajagopal case, Karunanidhi's case, which was cited by the petitioners, is wholly inapplicable, my lords. That is a one-paragraph judgment, and the finding that is given in that judgment is that dissolution of state assembly will not be a ground to hold that the constitutional machinery has been broken down in the state. Rajagopal case relies on UNR Rao, which is delivered by the same bench of your lordships. In UNR Rao, the contention was that a writ of quo warranto was sought against the Prime Minister and her cabinet. The contention was that since the House of People has been dissolved, and since the cabinet is responsible to the House of People under Article 75(3), the president should dismiss the cabinet. Your lordships rejected this contention and said that Article 75(3) will only apply where the House is not dissolved or prorogued. So this case is wholly inapplicable. My lords, my note is on volume 6, PDF page 50. Kindly consider that. I'm grateful.
My IA is, my lords, 146764, my lords.
Yes, Mr. Bhushan, what do you have to say?
Yes, my lords. I have to say, or make only one summation that this temporariness and permanentness of Article 370 has to be looked through the prism of word further in the preamble of Jammu and Kashmir, read with Section 3 and 147 of Constitution of Jammu and Kashmir also. Even Constitution of Jammu and Kashmir has not given power to itself to amend Section 3, where it is said that it is and shall be the integral part of Jammu and Kashmir Constitution of India. And second is will of people. This was argued strenuously.
Lordship, I appear.
Yes,
for,
Dr. Khanna.
Lordship, I appear for Youth for Kashmir, Pannu Kashmir. We were the people who were displaced in 1990s, whom I represent. Lordship, my first point of submission is when the instrument of accession was signed, that day it was complete and formal integration with India. And
that point has been made. What is the next point?
Lordship, the second point that I wanted to make, that because of 370, there was no economic integration with India. That was we were making. And the other point I wanted to make was regarding the women's right, which Ms. Pathak has made. And Lordship, the final point I want to make it till 2016, even transfer petitions could not be filed in this court under the regular provisions. We have to approach under 32 or in the other provisions.
Thank you. Yes, yes, sir. What do you have to say?
19618, my lord. In my matter, my lord, no counter, no students has been filed. I got a letter circulated on 27th July, my lord, saying therein that I shall be able to file written submission only after hearing both the parties. Now I have may kindly be allowed to.
What? And what is that SLP?
118, my lord.
Filed by whom?
Filed by whom actually? You are the SLP petitioner.
My lord.
What is the order that you are challenging?
My lord, I am challenging the order passed by the High Court, my lord. I sought there, my lord, to declare Article 370 a left provision. Second, my lord, declare separate constitution for the J&K void ab initio.
That is
my lord, that I am seeking permission. I am seeking permission to file written submission. In view of my letter, my lord, which I circulated on 27 July.
So we'll come back after.
Yeah, why,
After
during
hearing-
recess, may I just
Going
file
through my
minutes,
law-
my submission so that they are on record, my lord?
My lord, after going through my. written submission, my
They are
lord-
longer
Because
than.
I have to
the main
reply, my lord, I have to reply, put
They
it
are
down.
longer than the main arguments.
I'm sorry?
You can open your
My
submission,
lord,
we'll see.
permission
That's what I'm
may
saying,
be
my lord,
granted
that I
by
will.
the Lord
We'll hear you, Mr. Sibal. After lunch, we'll hear you.
In the meantime, I should be able to file, my lord.
They are longer than the main submission.
One
Let
second,
your
you have
lordship-
filed hundreds of documents, I never objected, even my
Already
first submission, you never,
We'll
what is
reflect
all
on
this?
it at lunch. We'll
My
hear
lord-
you at lunch.
Written submission may can be permitted to
Well, if
file,
you-
my lord.